Hello, everybody. Hope everyone is having a good day today. Okay, everyone's logging in. That's good. We're going to start in about 5 minutes as soon as we hit 10 o'clock. Nobody wants to be on video today. That's funny. I can't see your smiling face if you're not on video. Hello, Deborah. How are you? Toby, how are you? All right. We are filling up fast. I hope everybody, Marla, good morning. Hello, Bob. I hope everybody is having a phenomenal season so far. I can tell you in our office, we are out of control busy. Lots of closings, lots of things going pending in the MLS. So check every day. Okay. About 3 minutes, we're going to get started. We're going to go over the red line of the new NABOR contract changes. Let's see here. Good morning, Kat. Long time no see. All right. Connie, good morning. Let's see. So the way this is going to work, if you can unmute yourself. I don't have it locked muted, at least it's not supposed to be. If you have any questions, you can put them in the chat, or you can just shout out your questions as we go through this. Good morning, Mr. O'Rourke. Good to see you. Once we're going in the presentation, you feel free to interrupt me anytime. Just shout out your question into the chat. The Q&A. I don't know if that's working or not. Let me see where the Q&A, where the Q&A is. No. Good morning, Frank.
Good morning.
Okay.
They changed the contract, so they're doing the double.
Okay. 1 more minute and we're going to get started. I'm going to go ahead and share my screen. Okay, give me 1 second to get the chat back up. Where did the chat go? There it is. Okay. Perfect. All righty, it is 10 o'clock. We are going to get started with our review of the NABOR contract red line changes for 2021. So my name is Sam Saad. I am a real estate attorney here in Naples in Southwest Florida. We have offices throughout Southwest Florida, the Cape, Bonita, Naples, and Marco. We are going to be talking today about the changes that the NABOR Legal Resources Committee has done for the contract, listing agreement, and forms that you use every day in your real estate practice. I will tell you the form changes this year were light. This is going to be a fairly short presentation, about 35 to 40 minutes. And then we'll have time for questions. And I'll say it again, if you have questions, shout them out, type them into the chat. I'm monitoring the chat. We're going to go through the red line. Some of these are just cosmetic changes, and I'll just point them out quickly. There are a few substantive changes that we're going to talk about. Before I get started, just want to confirm, everybody can see my screen and see that it says addendum to listing contract. Okay, see a few thumbs up. Good, perfect. Okay, so we're not wasting your time. I'm going to dive right in to the first one here. This is the limited brokerage services addendum to the listing contract. Now, this form is typically used with our standard listing agreement to modify the specific brokerage services that you're going to provide and really limit your representation of your customer. And you can see here, we've really made just a few cosmetic changes. Let me get my laser pointer. You can see here, we've just made a few cosmetic changes. Brokerage services is no longer all capitals, and we had a grammatical correction here with that versus which. So simple changes. Okay, next one up. Well, you are probably very familiar with the addendum to sales contract, CDD, MSTU assessments. So this is somewhat of a major change. This is no longer an addendum. It is now a disclosure. It was always a disclosure. It was always required to be a disclosure, but NABOR was calling it an addendum. We're now just correcting that and clarifying that this is an addendum, a CDD MSTU assessments disclosure provided by the seller. You no longer put the buyer's name on here. Over here, we deleted all that. You put the property here as you always did. And then you have your disclosure of CDD assessments. And then here the seller discloses, the buyer no longer acknowledges. And then just as before, you put your capital assessment on the tax bill in this blank. You have to research, or you can call me and I will research where to get the annual capital assessment amount and the maintenance and operating amounts. Those two go in here and it will autofill into this blank down here for the CDD. Darlene, you should probably be the one to complete this with my assistance because you have to research the breakdown of the CDD assessment, and that is not easy to do. So when you're doing these, if you have any questions, just give me a call. If you Google the name of the CDD with the word CDD, you'll probably find the website for the particular development district, but getting through all the financials to get the right numbers can be very difficult. So just let me know, I'll help you with it. Or if you know how to do it, then one thing that we did provide, answering your question a little bit further, Darlene, is there is a list of all of the CDDs in Lee and Collier County with all of the contact information in your forms. NABOR provides that to the Legal Resources Committee, provides that to the realtors. So get those, get those phone numbers and call and get this information, or I can just look it up online for you. Lori is asking, when should it be presented? You should present it with the contract. It's not like the HOA addendum or the HOA disclosure, I mean, where you have to do it beforehand. You can present this with the with the contract. Darlene is asking, is the MSTU the same as an MSTD? No, they are not the same thing. An MSTD is put forward by the county, and it's for like the sheriff or for special fire or for certain districts, for certain beautification projects. An MSTU and a CDD are developer created, and that's why they're disclosed differently. And then here, this will all be on one page on your final form. Diane, yes, I can look it up at the beginning of the listing, yes. Yeah, that's another good point, Diane. Actually, you should put this CDD disclosure in your listing. If you have the listing, if you're the listing agent, and then your buyer's agent will just see it in there, and they should know to have it signed by their buyer, and you will have already had it signed by the seller prior to putting it in the MLS. Another change here, this disclosure is given in conjunction with the sale of the property. Buyer acknowledges the above disclosed liens and assessments and agrees to assume the outstanding capital balance, then everybody signs. Questions about this one? Okay. Okay, post-closing occupancy addendum. We did not make a great deal of changes to this, but there were a few that need to be discussed. Cleaned up premises versus property. The contract uses the word property, so we did that. In the contract, you are required as the seller to deliver the property in broom clean condition, free of debris, with ordinary wear and tear accepted. We had some attorneys that wanted to see that in this document. So instead of in the condition required in the contract, it now reiterates the condition required in the contract. Also down here, we cleaned up the liability. The buyer will have an action for ejectment or any other remedies available under Florida law if the seller does not leave. And the seller indemnifies and holds the buyer harmless against any claims, losses, or damages arising from their seller's negligent or willful misconduct, as opposed to seller's plain occupancy. So if there's an accident, then and it's the buyer's issue, it'll remain with the buyer. I think that's a good change. Okay, so last year when COVID came out and it was becoming an issue for our contracts, we created this COVID extensions. Well, we realized it was a good document and needed to be further utilized. So we removed the COVID language from this new amendment to sales contract. And you have options for changing the closing date, changing the finance contingency, changing the inspection period, changing the as-is due diligence period, the title examination period, or the clearance period to extend the contract on an as-needed basis. It's just an additional tool for you to use. Again, we removed all the COVID language and made this into just a useful document for you as the realtor. Let me just check one thing. Yeah, and this will very likely stay on 2 pages because of the length. Okay, so this document, the cancellation notice and directive resale condominium cooperative unit, as you're well aware, when you terminate the contract because the buyer is not happy with the condominium documents and they have their 3-day statutory period to do the termination, we just renamed it termination so that you would find it with all the other terminations as opposed to cancellation. So when your forms file is sorted in alphabetical order, now all the terminations will be together. So not a substantive change, but again, a useful change to help you with more efficiency in your practice. Okay, buyer's election and seller's response. So we clarified that under standard D2B, these are defective inspection items under standard D2B. This is a kind of a big change here. We deleted this reference to other. There is no other in the contract. The contract lists 6 specific inspections that the buyer can undertake. Hello? Oh. There we go. 6 specific questions that the buyer can undertake. the systems and equipment inspection, the radon, the lead-based paint, the WDO, the mold, and the permits. So there's no reason for other. We took it out because it was very confusing to a lot of realtors. So the part 2 remains the same. The buyer picks their credit and puts their amount. They have remedial action they can choose, or they can pick a combination and describe the combination here. Now, the other major issue in this form and in the contract was what happens when the buyer makes an election that is not in conformance with the contract. They want cracked roof tiles. That's the big one. They want cracked roof tiles to be a remedial action, new roof tiles, or a new roof, or a new air conditioner when the air conditioner is just leaking freon. So it used to be if the seller checked A, it alluded to the fact to the seller saying that they are going to accept and agree to buyer's election in part 2 above, even if part 2 had an improper election. So we added this additional language here that says as to defective inspection items only, and not as to cosmetic conditions or other inspection items. This is supposed to clarify that when the seller accepts the buyer's election, even if the buyer's election contains improper items that are cosmetic conditions, buyer accepts with regard to defective inspection items and only, and will undertake to repair them or give the credit. Now, this gets a little dicey still. We have not solved the problem when the credit is requested and then the credit is for the new roof or the new air conditioner, when a simple repair will make it in working condition or structurally sound and watertight, which are the tests under the contract. If you write $50,000 for the new roof in here, we're going to have we'll still have the same problem where I will have to send the breach letter and request that the buyer immediately correct their notice to comply with the contract, or we run into all types of other problems. But at least when your buyer makes a slightly improper election, we've remedied it part of the way. Okay. And then here under the list of inspection items which are defective, we added this note: the buyer should not request remedial action or credit for cosmetic conditions as defined by the sales contract. Just as a reminder to buyers, please don't request remedial action or credits for cosmetic conditions. Of course, that will still happen and we will deal with it as it comes. Okay, listing contract, right, and exclusive right and authority for rentals. So we had a few little cosmetic changes. Contract had a spacing issue. Not a big deal. Okay, so this is where we have the clear cooperation rule built into the listing agreements. I know that NABOR talks about clear cooperation, so I'm not going to spend a great deal of time on what clear cooperation is. I will say that when you sign your listing agreements for rentals or for sales, oh, I have questions, hold on. Let me go back real fast. I apologize, I missed a couple of questions and people are asking about this other form. I want to get everybody's questions answered. David asks, if a request for cosmetics items is made and an agreement is made and the addendum says no cosmetic items, does the requesting agent agree to repair without cosmetic items? Or do you have to explain to them what cosmetic means that is not acceptable to ask for? David, unfortunately, you are always going to have to explain those cracked roof tiles don't get fixed as long as the roof is structurally sound and watertight. That's just the test in the contract. And that's the way it's going to be. These buyers are always going to hear from their inspector that things are terrible. They need to fix all these little items, every nick, every scratch. And that's just not the way the contract reads. So that's always going to have to be explained. And that's correct, David. They cannot ask for cosmetic items. If an item is cosmetic in the contract and a buyer demands that the nicks in the wall be corrected, which are clearly wear and tear from use of the property, then the buyer would be in breach of contract. Lori asks, can't the seller just check off other and state not repairing cracked roof tiles? Well, there is no other for the seller to check off, Lori. There is acceptance, rejection, or counter. And if you check counter or rejection, the contract specifically says that the buyer has the right to terminate. So it's not fair to the seller if the buyer makes an improper election and then the seller is forced by a form to choose rejection or counter, and now the buyer has a right to terminate. That's why we added this additional language. The seller can now accept the correct portions of the buyer's election and reject the incorrect portions by checking box A. David says they will expect cosmetic items to be done. And as the realtor, you have to tell them, I'm sorry, your contract doesn't allow that, or just let me do it. Honestly, I don't mind delivering bad news. That's what lawyers are good for. If we need to talk to them, talk to your customer about what's cosmetic versus what's remedial action, I'm happy to have that conversation with them. Even if I'm not doing the closing, I can explain the form to them. Okay, any other questions on that before we move on to clear cooperation? Seeing none. Okay, so listing agreement again. So we're back in the listing agreement. The listing agreement had to be updated to comply with the clear cooperation rule. So now you check here, the property shall be entered into the MLS within 5 business days of the contract commencement date, or 1 business day after the public marketing defined below of the property, whichever occurs first. So public marketing is the any marketing that you do outside of your brokerage. So if you are in a big brokerage, national brokerage, and you send an email, I've got a pocket listing, and it only goes to your brokerage, great. Here's the problem. You're in a big national brokerage. There's hundreds of realtors. As soon as one of them sends that out to their customers, now the brokerage is engaged in public marketing, and the property's got to be put in the MLS within 1 business day. So really, there's no marketing if you don't check this box here. If you check box 2, you're not going to be entered into the MLS. You're not going to be you're not going to do open houses. You can't do flyers. You can't do anything public. And I know that NABOR has been very diligent about finding people who are not in compliance. They're giving warnings and then fining, so be very careful there. Okay. We updated the lines, so the forms should all have 5 lines, and as for notes for additional terms. Okay. This is the listing of residential improved property, exclusive right and authority to sell. This is your main listing agreement. Again, we updated for public marketing for the clear cooperation rule. Same thing as I was saying here. It's a little more clear here because I took out the deleted language. So this is your main listing agreement, and you just need to explain, hey, I'm going to put it in the MLS. They're going to say, somebody might say no. You say, listen, if I don't put it in the MLS, I can't tell anybody about your property. So just have to fight that battle with your sellers, especially in the higher end. Okay, we updated all the documents, took out addendum, the listing contract for CDD MSTU assessments, and replaced it with disclosure. So you're going to see that throughout here. It now says disclosure. We fixed the lines. Okay, when your broker signs now, there's now a place for them to put the date that they signed. That always should have been there. Remember, your seller and your broker sign the listing agreement. Your name is printed here as the realtor. You have to unmute yourself if you want to talk. I see a couple people trying to talk. If you want to talk, you've got to unmute yourself. Okay, this is the vacant land contract. Now in the vacant land contract, we made very few changes. One of the things that we did not change is, where's the MLS language? I want to point this out to you. Here it is. No clear cooperation rule, because clear cooperation does not apply to vacant land. So just be aware of that. Again, we updated for the disclosure versus addendum. I think that was the only change. And we added the lines and the date to the authorized broker signature. Okay, this is your main sales contract. We moved a lot of things around in your sales contract. We did not make a lot of substantive changes. I will go through them. And we fixed counteroffer, so there's some spacing errors there. Again, it's now a disclosure, CDD, MSTU assessment disclosure. Okay, so here the seller needs to deliver marketable title subject to the, as defined by the title standards and subject to certain restrictions, including, of course, a restriction in a condominium or subdivision. And we didn't ever say condominium before, so now we say that. Marla is asking, can a Naples agent who has a listing in Lee County require a buyer agent to submit NABOR contract forms? Of course, you can always demand that they use a certain form. You just may not get it. So you can absolutely, if you've got a Lee County listing, you can require a buyer's agent to submit the NABOR, the contract on the NABOR form. Yes, I hear a question. Joanne?
No, I was just saying,
Oh, okay. Yes, you are not restricted. The NABOR contract is valid throughout the state of Florida. It complies with Florida law. The only problem with using the NABOR contract outside of Charlotte, Lee, or Collier County is it does not itemize who the title insurance is paid by. It only covers Lee, Collier, and Charlotte counties. And of course, there's the switch between Collier and Lee and Charlotte.
I have a question. Do you have to be a NABOR member to use the NABOR contracts? If
you have to be a member of NABOR to use the NABOR contracts, yes, you do. They are copyrighted to NABOR.
So if you're a member of Bear, but you sell in Collier County?
Yeah, but Bear and Fort Myers, they all have that agreement where they all list each other's properties. So I think you would be okay if you were not a specific member of NABOR. You should be careful about that. I'd have to check with NABOR and get back to you to be certain.
Thank you.
I'm pretty sure that if you have access in MLS, then you have access to Form Simplicity. You're going to have access to the NABOR forms.
Right, I have access to them, but I've been afraid to use them because I'm not a NABOR member. I'm a Bear member. But quite often on the listings, the listing agent is requiring or demanding the NABOR contract. So there's a little conflict there.
And the other thing is, if you're doing a lot of work in Bonita, you might get a NABOR contract from a buyer so they can control the title insurance payment or company, even though the seller pays for it. So you may want to check that and be careful so that if you have the listing that your seller remains in control of the deal, because they're going to pay for title insurance anyways.
Right. So do you think I should call NABOR and ask that question, or would I be?
I will write that down and I will ask NABOR and I will email it out later about that, the licensing.
Thank you so much.
I'll email over to them and ask them that question. I'll send it out, Donna. Okay. Let's see. Diane is asking, I never placed my buyer's or seller's address in the contract because years ago I had one party show up at the other party's doorstep. Is this required? Diane, it is required because it's for legal notice purposes. So that's a little strange and creepy that someone showed up at the house, but it is required because if I've got to send a demand letter, I got to have an address and it's required to be in writing. So yes, I would say it's absolutely required to put your addresses at the top of your contract. Frank is asking, how long should the buyer closing agent provide a title commitment to the seller side, have a closing next week and still no title commitment from the buyer's closing agent? Well, Frank, that's determined by your contract. In the NABOR form, you have under standard A, not standard A, standard B, 10 days after the effective date, seller shall furnish buyer complete copy of the owner's policy, and then it should be 30 days after the effective date for them to get title and deliver it to the seller. So it just depends on your contract effective date, Frank.
Thank you, Sam. Thank you.
And you can call me offline.
Thank you.
Okay. So next change is really just some notices. We're in standard D1C advisements and acknowledgements. We added the fair housing brochure. You need to put this with all your sales contracts now. It's in your forms file, a form simplicity, zip forms, all the app files. It should be in all those. The fair housing brochure is now a part of your contract. And then we added an advisement for the FEMA 50% rule. So the FEMA 50% rule says that if your home is below the floodplain, which is the flood insurance rate map plus 1 foot, then the buyer is going to be restricted to 50% of the value of the structure when they go to make changes to the property. So if you've got a $400,000 lot in Lake Park with a $50,000 structure on it, then your buyer is going to have to bring that lot into compliance with the floodplain, or they're only going to be able to spend $25,000 on their improvements, and they're going to have to make improvements over time as opposed to all at once. So that's something that your buyers need to know. And the FEMA, I'm sorry, the flood elevation comes with the survey, which is usually not, which is by this contract, not required to be given until 5 days prior to closing. So you got to be very careful that you understand where you are in the flood maps. And you can get that by calling the county or the city. In a lot of instances, they have pretty much every property platted on the flood map. So if you want to know this information prior to getting your survey and your elevation certificate, you can request the information from the county or the city, and they may have that. Okay, this is a realtor request, the next change. The inspection period default has always been 15 days, and you never had the opportunity to change it. Well, now you're going to have the opportunity to change it. 15 days will be the default again, but this blank is here now, so you can go in and amend the inspection period up or down as needed. Then we capitalized open permits, took out building because we use open permits as a defined term in the contract.
I have a question about when it says 15 days after effective date, do you start counting on the day after the effective date, or do you start counting on the effective date?
Day after, 15 days after. So it's day one is the first day after the contract is executed.
Okay, thank you.
Yep. So if you signed on the 1st, your 15th day is the 16th. If you sign on the 31st, your 15th day is the 15th. Okay. Then we go back down here and we added some definitions for collectively the defective inspection items. And then we made some changes. Now this is a lot of red line on the screen, but it's a lot of moving things around and clarification. So don't get concerned that we made a bunch of changes to the NABOR inspection election process. We did not. What we did is we clarified that the seller at seller's expense may make or cause repairs, replacements, treatments, mitigation, or other remedial action. Collectively, we call that remedial action. They may ask for a credit in lieu of remedial action, or they can ask for a combination. And all of these together is referred to as the buyer's election. So that's all we really did. Now, one other major change, question. Is it calendar days or business days in the NABOR contract? It's calendar days, you may. It's always calendar days. Skipping holidays and weekends only when the deadline ends on the particular holiday or weekend. Okay, now another fairly significant change here. Except for buyer's permit election, the buyer shall be entitled to one buyer's election. So no more multiple elections. You know, you find something else wrong, you go back and make another request. You get one election. Jim is asking, who determines the fair market value of the structure? Jim, it's the property appraiser. It's on the property card for the county appraiser. They break out land value versus structure value. Okay, and then we have now a permit election. Notwithstanding the deadline stated in this standard D2, if buyer requests a permit search from the applicable government agency with permitting jurisdiction over the property within 5 days of the effective date, and the permit search results are not obtained within the inspection period, the time period for the buyer's election with respect to any open permits is hereby extended to 5 days after buyer's receipt of such permit search. In such case, seller's response deadline with respect to buyer's permit election is extended to 10 days after receipt of buyer's permit election. So you make your request within 5 days to the county. They're going to take 2-3 weeks to get it back. As long as you're 5 days, as long as you're prior to closing, the permit search is extended to 5 days after receipt of that permit search. Then the seller gets 10 days to evaluate and figure out what they got to do to correct it. But nothing here extends the closing date. Nothing in this paragraph shall extend the closing date. So all this has to be done prior to closing if it's going to happen at all. Okay. Yeah, Yasmin is correct. If you don't like the county's valuation, you can get a FEMA appraisal done. They're expensive, but you can do that. Okay, the other thing here, this is a change that is fairly significant, especially in the downtown area where there's a lot more wood rot from the older homes. The roof, ceiling, interior door and exterior doors, walls, foundations, swimming pool, spa, pool deck shall be in working condition if structurally sound, watertight, and free from wood rot. So all that little wood rot around the corner, the door jambs on all these homes now has to be corrected. It's now a remedial action item. Okay, we added extreme weather conditions to the risk of loss. So if due to a pending or threatened hurricane, tropical storm, or other extreme weather condition, the buyer cannot get insurance, or if services essential for closing are not available, the buyer or seller may delay the closing until 5 days, not more than 5 days after these insurance or services are restored. I will tell you right now, we are in a situation where services essential for closing are not available because all the federal shippers, FedEx, UPS, DHL, are all shut down due to the snowstorms in the north. For example, Memphis, you can't get a plane out of Memphis. We can't get any FedExes. So if you've got a closing going on and you can't get your package out of FedEx because of the snowstorm, this provision will protect the buyer and the seller. Keep the contract together. Okay, let's see. Lori, you have a question. With buyer's one election rule, what if they don't receive the permit information within the 15-day period? Lori, the permits are an exception to the one election rule. It's in the language here. Let me just sealing and water stains are not mandatory, Dale. Lori, let me answer your question here. Notice here it says if they're not obtained within the inspection period. And then up here it says, except for buyer's permit election, the buyer shall be entitled to one buyer's election. So you get a regular election and a regular permit inspection election, and then you get a permanent election separately. Okay, that should be all the changes for the main contract. Oh, we did add seller's rejection language back into the contract at the request of several realtors. I don't know why it's there. I've never seen it used, but some people like it. Allegedly, if you are concerned that your seller may not have seen the election, or sorry, seen the contract, the offer, and you want some proof, you can ask your listing agent to get it signed. There's no obligation to sign it though. Vacant land, we did some cleanup here. There were some spacing issues. Again, spacing. Again, with the CDD disclosure, no longer an addendum. Vacant land, we added the extreme weather and the fair housing. We did not add the FEMA to this one because the obviously the FEMA wouldn't apply. Errol's is asking, can you give us an example of the FEMA and buyer's election? Errol's, those are different issues. FEMA would be if the property was below the floodplain as determined by the elevation certificate, then you would be limited in the amount of improvements you could do to the structure. And then of course the buyer's election is different, and FEMA is not accounted for on that. FEMA comes up as a survey issue. Okay, the as-is contract, again, we did not make a lot of changes, just some cleanup here. You can see, again, we changed CDD assessment disclosure. Okay, again, with the spacing, counteroffer used to be dashed, and that was they changed that. We added the fair housing, the FEMA rule to the as-is because it applies to the structures again. We added the extreme weather condition to the as-is. Let's just keep going. I think that is going to be all the changes. There might be one more at the bottom. And again, you can now with the rejection, Mary, yes, I will put a copy of the marked up docs in the chat in a few minutes. Okay, termination. So we cleaned up the termination. We took the word instructions off here because it's not instructions. This tells you what the form is for. We took as is off the top here and we added it to the bottom. So we cleaned this up and we added the sales contract vacant land due diligence period to that, to the termination notice. You of course know that you use this termination notice when you're terminating from the buyer, and there's also one for the seller, but we just made the changes on the buyer side. With that is all of the changes. It was like I said, a light year. And I have time now to answer any questions that people have. You can put them in the chat or unmute yourself and shout them out. Any questions, concerns? What I'm going to do is I'm going to add red line. There you go. So you should be able to download that PDF from your chat. Oops. Let me do that again so it goes to everybody.
I have a question when you're ready.
Yep, Donna, 1 second. The updated contracts, Todd, will be available in the next couple of weeks if they're not next week. I think it's going to be the 3rd or 4th week of February. Okay. Okay. Kathy, you're asking about the election form. You mean the inspection election form? Just remember that you no longer have the other box. You check the actual inspections that you completed under the contract. There are 6 of them. And then you fill out the buyer's choice. And if the buyer elects something that they weren't allowed to elect because it was a cosmetic condition and not a broken item, a system or equipment not in working condition, the seller can now check box A in part 3, and they don't have to worry about breach of contract. Okay, let's see what we got here. Darlene, I think that you have to provide those documents. She's asking about providing links to all these addendums. I think in some cases under federal law, you actually have to provide the documents. Bob, so your question, do the buyer and seller both have to sign the contract termination notice? The answer to that is it depends on your title company, it depends on the circumstances. I require it to be the buyer and seller to sign off when there's a known dispute. If it's day 3 of a 15-day as-is free look and the buyer terminates and it's clear the buyer terminated and everybody got notice and the seller just is being a jerk about it, I absolutely would just return the money to the buyer and tell the seller, hey, sue everybody, we'll see you in court. But in close calls or contested cases, I would not do that. Let's see here. Is a GFI part of defective items for safety? Having the proper GFIs are defective items, yes. Aileen, I do have a NABOR contracts class. You should sign up for it. I think it's tomorrow. All righty, everyone. Let's see here. David is asking if they ask for cosmetic items that are not allowed, the seller agrees does not have to do the cosmetic items. David, you always have to explain it. You always have to explain it to these people because the buyers and sellers don't know. We're the experts. We deal with this every day. So you got to explain it to them every time. Kathy, it says if they ask for an exaggerated credit, does the seller have any recourse? Yes, they do, Kathy. You would put the buyer in breach of contract and tell them to bring you the corrected inspection election, or you're going to go after their first deposit. That's usually what we threaten.
I didn't understand that.
You can do an online search, Miranda, and that's very easy to do now with the CityView website in Collier County, and I believe they have a similar feature in Lee County to pull up the open permits and send them in. Excellent. Okay. Let's see. Anita, I'll have to come back to you with your call me, Anita, on your question about the lease, and I can go over that with you separately. Okay. Mona, yes, if it says furnished, it could include the things in the garage. Let's see here. Any other questions?
Sam, can we get a copy of the marked up in a PDF version? Any way to get a copy of these forms?
Don, they're in the chat. Scroll up in the chat. I put them in there.
Thank you.
Someone's saying they're coming
Yeah,
up blank. Let me
Sam.
try and do it again. Put it in the chat one more time. See if this works. Yep. Okay. Okay. Donna, did you have a question?
Yes, back to the permit search.
Sure.
Is that just in reference to open permits, or is that via unpermitted?
There's a definition in the contract for unpermitted improvements, open permits, code violations are all considered open permits.
And you said it takes sometimes 2 to 3 weeks. So you really can't close a property in just 2 to 3 weeks if you take that into account. What's your advice on that?
It's a seller's market. Sellers don't care. They want those properties closed as fast as you can. Buyers are going to take some risk. You can go on the CityView website, look up the permits and see if there's anything out there.
Right.
If you know the link, I've got access to the old permit search. I can go back to the early 2000s. But if there's a 1979 pool permit that's open,
Right.
you're not going to get it in time.
Okay.
So, because those are on microfiche, it's just the way it is right now with the market. I mean, sellers are forcing these closings. They don't want to hear about lien searches. They don't want to hear about permits. They just want their money and they're getting it.
Sure.
So I would say in a buyer's market, you could run your timeline a little bit longer. You could do all the required searches and get everything back on time. But right now you're kind of at the whim of the sellers. I mean, there's just nothing to buy.
And do you automatically request, I mean, does the buyer have to request for your office to do that, or because it's in the
When the
contract?
buyer signs their buyer information form with my office,
Right.
then we will go and we will order the survey that they requested. We will order the lien search and whatever else we need to do to get it moving the title commitment right away. We don't wait.
Right, okay. Thank you.
Hey, Sam,
Yes.
listen, I stepped away for a phone call and I caught the tail end of that cosmetic changes. So,
Yep. Dan, this whole thing is being recorded. It'll be on my YouTube channel in about an hour
oh, okay.
and you'll be able to see the whole thing. But Kathy's asking, is an MSTU and an MSTD the same thing? No, they're not, Kathy. One is government created, one is privately created. The MSTU is privately created. Kat, you have a question?
Yeah, I want to know when this is going to be in effect.
The new
All the
form
changes.
should be out in about, I think, a week or 2 weeks.
Okay, thank you.
Yeah, they should be out. I think the goal was March 1st.
Okay, I don't see on the chat the forms that you're saying. I would like to have a copy of that as well.
All right, scroll up. If you can't see them, I'll email them out.
Yeah, I already checked. It's not there. Okay,
All right,
Thank you.
I'll email you.
thank you, Sam.
Cool. Any other questions?
Sam, I have a question there that I put in chat.
Yes, lady.
About, I just recently heard that this one agent had a contract on a property that was advertised in MLS as turnkey. And then after the signing, the agent asked the agent, the buyer's agent, if the buyers wanted to buy the furniture.
So Diane, you run into an interesting question there. The property may be listed as turnkey, but if you sign a contract that does not include the furniture, the integration and merger clause of the contract wipes out everything that happened before the contract was signed. So if it's not in the contract, it doesn't transfer.
All right,
Not a
thank you.
nice thing to do. It's a possible fraud claim, depending on the situation, but there's an integration and merger clause in the contract. So if you're buying turnkey, write turnkey right there in the personal property section on page 1.
All right, thank you.
You're very welcome. Don?
We were just commenting on that, the furnished or unfurnished. We were just talking to ourselves. Sorry to interrupt.
No problem. All righty, everyone. I said this, I would only keep you for 45 minutes. It's been 48 minutes. I'll give you one last shot at questions and then we're going to wrap it up for the day. Anybody?
Thank you, Sam. Really appreciate it.
You're very welcome.
Well
Mark
done.
is asking, can all the forms be signed in counterparts? Yes, you can.
Thanks, Sam.
All right,
Thank you for your time,
all.
Sam.
Great to see everybody that turned their video on. Talk to you all soon.
Thank you, Sam.
Bye-bye.
Sam.